I love.
Yeah. Okay, everybody's
Do you see him?
not yet. Hi, everyone. Bear with us. We're working out some technical kinks, but we should be starting the presentation in about 5 minutes.
He's there.
Okay, the judge is here almost. Welcome, Judge.
Thank you.
Technical,
Oh, well,
well,
almost defeated by technology.
I know, well. all
Failed then. We failed then if we didn't defeat him.
of- Now we gotta get Jeff in. Um,
Jeff's in.
Oh, Judge, well, we're being recorded though. Well,
Okay, I think we are all here. Thanks, everyone. So let's just give it one more minute to have the attendees come in. I know we've got about 110 people registered. Just give it a couple more minutes and then we can get underway.
when we do the screen sharing, Judge, we're gonna put that one exhibit up with the statistics, but it's gonna take up the whole screen. So we'll all look at it and then, I couldn't hear you. Oh,
No, that's fine.
oh, I'm
That's fine.
sorry.
Whatever you want. Okay.
Yeah, we can't put it on the side. You know, wait till we get to maybe 70 or 75.
Sure. If I lose a little power, move this screen, but I figured out a place to put it, so we'll just have to deal with that, if that happens. Well, why don't we start?
Yeah, I think that makes sense. Let's get
Okay.
rolling.
Okay.
Okay, so good afternoon, everyone. I just wanted to take a minute of your time. I'm Monique Olivier. I'm the president of the Federal Bar Association for the Northern District. I just wanted to thank the panelists for today, especially Judge Breyer for taking time out of all of your incredibly busy schedules to share your expertise with this crew. The subject matter of the panel today is both extremely interesting and extremely timely, focusing on what is happening with federal sentencing and the trends we're seeing at the U.S. Sentencing Commission. And for those of you who are not FBA members, I also wanted to encourage you to join. The FBA is a nonprofit that supports federal practitioners and works closely with the judges in our district to promote legal education and some policy work and networking opportunity. In particular, we advance nonpartisan policies such as increasing federal judgeships to handle the extreme backlogs that we're seeing in our courts today. And the programs we put on are offered through the generosity of our members who support us through membership dues, and our executive committee and volunteers like our panelists today who offer their time to host these events and share their knowledge with the bench and bar. I'll add a link in the chat to FBA membership opportunities. Take a look at that if you can. And then finally, I wanted to thank Randy Sue Pollock. She's one of the vice presidents of the FBA for the Northern District, and she has worked tirelessly to put on a number of events for us and pulled together this amazing panel of speakers to talk with you today. So without further delay, I'll turn it over to you. Randy Sue, thank you all. Enjoy the panel.
Thank you, Monique. I'd like to welcome everyone to what is going to be a very informative and I hope lively discussion about the United States Sentencing Commission and our guidelines. We're honored today to have Judge Charles Breyer present, who is the co-chair and only commissioner on the United States Sentencing Commission. We are also joined by 3 esteemed members of our court family. I'd like to introduce everyone now. Judge Charles Breyer was appointed to the Northern District California bench in 1997 by President Clinton. He assumed senior status in December of 2011 and remains quite active on our bench today. He was the co-chair of the United States Sentencing Commission from 2013 to 2016. And in 2017, he was confirmed by the Senate to serve a second term on the commission. In 2018, Judge Breyer was selected as the recipient of the 34th annual Edward J. Devitt Distinguished Service to Justice Award, which is the nation's highest honor that can be bestowed on an acting Article III federal judge. Each of our other panelists have each assumed new positions in their career. Jody Linker is our newly appointed federal public defender for the Northern District of California. Jody was a law clerk for Judge Breyer from 2003 to 2004. After that, she worked as an associate at Clarence Dyer and Cohen in San Francisco and joined the Federal Public Defender's Office in 2007. Congratulations, Jody, on your appointment. Catherine Greer was a probation officer in the Northern District of California from 2011 until February of this year. Prior to that, she had served in the Central District of California as a probation officer. In the Northern District, she works exclusively in the pre-sentence investigation unit, serving as a line officer, a guideline specialist, and a supervisor. She conducted approximately 400 pre-sentence investigations that she wrote, reports that she wrote herself, and she approved over 3,000 pre-sentence reports as a supervisor. She is now using all of her expertise from her many years as a probation officer to start a new chapter in her life as a mitigation specialist. Our final panelist is Jeff Nedrow. Jeff is no stranger to those of us who've practiced in the San Jose division, where he has been a prosecutor for almost 27 years. Jeff started in the San Francisco division of the U.S. Attorney's Office as a paralegal on a SALSA in 1992 to 1994. And then he moved to San Jose, where he was the deputy branch chief from 2009 to 2011, and the branch chief from 2011 to 2019. I'd like to congratulate Jeff on his new appointment as first assistant in the United States Attorney's Office. The first part of our program will focus on the guidelines and the commission, and we will hear from Judge Breyer. Before we begin, I want everyone to know that this program is being recorded and will be posted on the website to the Federal Bar Association, Northern District of California chapter. We're going to hopefully have 15 minutes rather at the end of the program for questions and answers, but there is a Q&A portion on the webinar where you can post questions. and we'll try to get to them during the program if possible. Don't put them in the chat, put them in the Q&A portion. At this point, Judge Breyer, I'd like to turn the program over to you and ask you to provide us with background on the role of the Sentencing Commission, its priorities, what it's been up to, and what its current status is.
Well, thank you very much, Randy Sue, and it's a pleasure participating in the program. I think I could give a rather brief report on the Sentencing Commission because it is by statute 7 people, of which 3 must be judges, and it must be bipartisan, not nonpartisan, but bipartisan, with the president being able to appoint 1 additional person, the 7th person, as the chair from his political party, if he so chooses. However, in the last 2 or 3 years, terms have gone unfulfilled, and that is that people have cycled off the commission, and finally we get to me. And as I'm fond of remarking, for those of you who followed the Muppets, it's like Miss Piggy saying, the commission, c'est moi, because right now I am the only member. Well, you might think that gives me extraordinary powers, but the Congress thought that this might create a difficulty, and so it required a quorum of 4 in order to enact any amendments to the sentencing guidelines. We can do other things, but we cannot amend the sentencing guidelines. So the question is, what have we been doing the last couple of years? And it really turns to the second part of the commission's responsibility, which is to study sentencing and to issue reports as detailed as possible on different aspects of sentencing. Recidivism being one, compassionate release being another, types of offenses, the impact with respect to gender, with respect to age, all sorts of questions that one might have in terms of sentencing. And over the last number of years, we have issued reports on particular aspects of sentencing. The way those reports are generated is that every federal sentence is entered into a data bank reflecting all of these different factors, and then studied collectively and also by districts or by circuits or so forth, in order to determine what are the real practices of federal judges. What do they actually do in terms of sentencing? And that material is made available and has generated a lot of interest, I think, in terms of what are the practices of judges in sentencing. So that's our task. Our task basically is to give guidance to judges and to others who use the federal criminal justice system, and the commission has done that. Where it has not stepped up, of course, are amendments to guidelines, which are sorely needed, and I'm sure we'll get into a discussion of that.
And when did you last have a quorum, Your Honor?
Oh, I think maybe 4 years ago. One of the last things we did was to make the drugs -2, that is a reduction of sentences for particular offenders, and make it retroactive. And in that regard, we had a unanimous commission.
Okay. I've noticed, I went to the website and I saw that there were a number of infographic reports and data reports that you issued last year, dealing with mandatory minimums, as you said, and recidivism, and the elimination of proposals to eliminate the increased penalties on cocaine charges. Do you receive feedback from those reports so that you know that they're being used or read by?
Oh, yeah. We receive a lot of comments. I mean, of course, with the pandemic, it's been very difficult to get together. But we've had seminars, training sessions remotely, and people have been able to express views that way. Now we are going back into meeting. There's a sentencing institute that is set for Boston in June with probation officers and other interested people, judges who may participate in it. So I think we'll get a lot more feedback. But you're quite right. You know, it's never been in isolation. It's part of a much larger picture, and it's very helpful to see what judges and practitioners and special interest groups think about any particular sentencing issue.
Mhm. Do you reach out amongst your colleagues here in the Northern District for feedback on the reports that you've been working on?
I don't have to reach out because they in fact come in and tell me what they think of it. No one is shy. But I will tell you that we live in the Northern District of California in some kind of bubble. You know, I don't think we are reflective of all national sentencing practices. To the contrary, I think that we are generally, for particular types of criminal offenses, quite, let's see, I wouldn't say idiosyncratic. I think I would say different from a number of districts in their practices with respect to sentencing.
Okay. Is there any district that might be similar to us?
I would say sometimes the Southern District of New York in particular areas, sometimes perhaps the District of Massachusetts, I think are probably more similar to the Northern District of California than perhaps other districts, especially the Southern District of New York.
Okay. And what I'd like to turn to now is a discussion about the most recent report I think you issued, which is compassionate release. And you have been very outspoken about the need for more commissioners so that you have a quorum to address the changes that impact individual offenders seeking compassionate release. I want to discuss the significance of this report amongst everyone, but there's the statistics to one of the exhibits to your report I'd like to share on the screen so that for individuals who haven't looked at it, they'll see how many grants of compassionate release were given in the Ninth Circuit and in our district. So, and perhaps Judge, you could speak to what this analysis that you see right here.
So if you look, and you'll have to squeeze it larger, but if you look at California Northern, you see that 112 during the fiscal year, I think it ended 2020, but I'm not sure. I'd have to take a look at the date. It's not the most recent experience of this last year, but it does cover a period of the pandemic. We received 112 petitions and roughly granted 51%. And if you compare us, as an example, to Florida, where is that? That's happily in the 11th Circuit. And you take a look at the Southern Florida, you see that they had approximately twice the number of petitions, and their overall grant rate was 30%. So there's an appreciable difference between the practices of judges in this district and the practices of judges in Miami. Now, let me say a couple of things about compassionate release. Number one, the First Step Act, which I think was a very, very important piece of legislation, made one enormous change in the practice. Until the First Step Act came into existence, the way compassionate release would be obtained, because that's not a new concept, would be that the warden or the director of the Bureau of Prisons would have to initiate that relief, and the prisoner, the defendant, had no recourse to go to court if in fact the director of the Bureau of Prisons failed to initiate it. The First Step Act provided that after, I think it's 30 days, after a request of the warden or the director of the Bureau of Prisons, in the event that there was no activity by the director, the defendant could file a motion in the district court. And as a result, we went from a very, very low percentage of motions being filed to where we are today. That's number one. So it was a sea change in how relief could be applied on a national level. And it really did make all the difference in the world. Now, our district, like several other districts, but not universal, had the cooperation of the United States Attorney and the public defender in reviewing these petitions and seeing whether they could come to an agreement as to whether or not relief should be granted. And I received, and my colleagues received, any number of petitions in which it was basically by stipulation that the parties believe that relief should be granted. And in those cases in which there were one side or the other didn't agree to it, I mean, it would be the government not agreeing to it, the court then had to rule and exercise its discretion. But we were aided enormously by the federal public defender and the United States Attorney. And that, I think, bespeaks of the practice in this district that I don't know whether it's unique to this district. I only practice in this district. But it really is very, very valuable. The problem with, and I think the chart that Randy Sue just showed you, the problem is that compassionate release, the success of a petition for a compassionate release was a function of where you were. And it wasn't a function of your illness. It wasn't a function of the extent to which COVID presented a danger to your health. It wasn't a function of any of those things. Though when I say a function, those all contributed to it, but that wasn't the turning point. The turning point was, where were you? Were you in the Northern District of California? Were you in the Southern District of Florida? Were you in Oshkosh? I don't know, but that did make a difference. Now, one thing, without sounding rather boring on the subject, is that the Sentencing Reform Act is designed, whether it's a good idea or not, it's designed to promote national uniformity. And so then you had relief that wasn't being uniformly applied. Now, whose fault is that? I'd say that to some extent it was the Sentencing Commission's fault, because we were told by Congress to set up a set of criteria that would be applied nationally, compelling reasons for granting or deny or the granting compassionate release. And we were never able to do so because we needed a quorum on the Sentencing Commission. And I would guess that we'll get soon, we'll get a quorum.
And I believe Justice Sotomayor did speak out calling for more commissioners to be appointed, and you responded to that, I believe. Yeah.
Well, and it wasn't just Justice Sotomayor. It was also Justice Amy Coney Barrett.
Correct. Yeah.
So I think that probably represents some breadth of distance in terms of ideology on the Supreme Court.
And do you think that once there is a commission, this will be foremost in one of the changes?
Yes, I think this is a relatively easy change to make or a problem to address. They'll have to address safety valve. They'll have to address any number of issues. And obviously they have to address reform of the sentencing guidelines.
Okay. Do the panelists have anything they want to chime in, Jody or Jeff, about the number of compassionate release motions your office has seen?
Sure. Thanks so much, Randy Sue. There, of course, was a significant increase during the height of the pandemic, and as one might expect. And I appreciate Judge Breyer's comments, because we took them seriously, and I tried to take an individualized approach on all of them as to whether or not there were criteria that met the statute and the First Step Act, as we should have. And the numbers have been dwindling since then, with, of course, the progress of the vaccines and other, aspects that society has seen, I think, of managing the pandemic, within certain parameters. The one point that Judge Breyer made that I really thought was interesting was trying to figure out an approach that was standard, but also, it's just like with the guidelines, balancing uniformity across the country, but of course, unique aspects of the community. And on those motions, it's sort of the same thing. There's applying the law, of course, and the aspects of it that are standard, but also taking into account each individual's unique health circumstances, as well as aspects that may have called from this remaining custody, whether it be potential danger to the community or other components of it. The number of those does appear to have dwindled significantly. And of course, we're all hoping that the pandemic's worst aspects are behind us. And hopefully that leads to safer environments, of course, in the difficult challenges of a custodial setting, as well as a safer environment for us all outside of those settings.
Judge, do you have any ideas on what standards you'd like to see put into the commission regarding compassionate release?
Actually, I haven't thought about that. And I haven't thought about it because I won't be there. There will be 7 new commissioners. They will grapple. I think they have to study what were the reasons that were given. And actually, in the compassionate release report that came out a month ago or 2 weeks ago, they set reasons. They set out what the reasons were the judges gave. And I think you have to figure it out, study it, and see whether you can arrive at some consensus. I mean, it's interesting. When Judge Ketanji Brown Jackson was on the commission, I served with her. And again, it was a bipartisan commission. We had Judge Pryor, we had Judge Reeves, we had Judge Friedrich, people who were Republican appointees, and I would say to varying degrees quite conservative in their looking at it. But the commission was committed to following the evidence. What is the evidence? What actually happens? Why did judges sentence a particular way? What are the statistics, especially as it relates to recidivism? What does the evidence show? Does the evidence show longer sentences are safer for the community? Well, the answer is up to a point, yes. And then afterwards, it probably doesn't make any difference. And then again, it does make some difference. So, I mean, it's all laid out in our recidivism reports, but very, very interesting. That's the evidence. And the commission tees off on evidence. There was one thing I know that you were interested in: fraud. What about the fraud guidelines? And you referred me to an article which is highly critical of the application of 2B 1.1, the fraud guideline. And maybe this is a too long an answer, but I want to tell you, I and my fellow commissioners some years ago were very concerned about the measurement of loss in terms of fraud. So we were aided in large part by a wonderful ABA report that a number of people, including Judd Rakoff and I think John Gleason and others contributed to, which analyze how you should measure loss, which is very different from the way that the guidelines provide for measurements. And I think it is, much of it makes a great deal of sense. So it would be it's a rather large task to take on a guideline, an area, and try to reconstruct it in some way. I mean, you first you have to really figure it out. You have to figure out what's important, and then you always have to keep an eye on the fact that Congress can upset the whole thing if they don't adopt it or allow it to go forward. Anyway, we looked at all of these components that the ABA had put forward, and we looked at it in terms of what were judges' experiences. And this is what we found. We found that basically, when the loss was under $1.5 million, judges followed the guidelines. There was a very, very close adherence between the guideline range and what judges nationally impose in a sentence. From 1.5 to about 3.5, it started to deviate. And from 3.5 on upwards, it really varied. It really deviated. And so we took a look at that. And we also looked at it in the context of how many cases come up. And approximately, I may be wrong on this statistic, but I think I'm right, is approximately 85% of the application of 1B, 1.2B, I'm now getting confused.
2B 1.1.
2B 1.1, that's what happens. I'm sorry to say, that 85% involve losses under $1.5 million. So when you were talking about these wide divergences or wider divergences between practice and the guidelines, you're really talking about a small subset of cases. You were talking about approximately 15%. I'm not saying if I were in that group, that it wouldn't be important to me. But then the question is, well, look what judges are doing. They're varying anyway. And so do we want to spend a year redrafting that guideline to make it more rational for everyone? Or should we devote our time, which is really limited, to trying to do some other things? And we decided to do some other things, especially in the drug area, and in illegal entry areas. We thought that was more significant. And if you take a look at the statistics, you will see, though it's less true now than it was when in the last 5, 7 years, 10 years, that immigration, drugs, and firearms are the 3 largest groups who are sentenced under the federal guidelines. And fraud, which is a number, I mean, it's not insignificant, but it's not nearly as significant as those other 3 areas. And so that's it. I mean, that's the explanation. You know, if we could do everything, we would have done everything. But frequently you can't.
Mhm. Jody, what are your responses to what the judge just said?
Oh, she'll agree with me, I'm sure.
We only have 57 minutes left, so where do you want me to start? Well, I will go back to some of the compassionate release stuff that we started with, which is I think it's great to see the statistics of the number of compassionate release motions that were granted in this district. I might venture to say that it was the lawyer showing discretion about which one should be filed, and so really they filed those motions that they thought had merit, and so they weren't just willy-nilly filing them. And just to give a shout out to the panel members, it wasn't just our office, it was the panel too. And it really was a community effort. And in those early days of the pandemic, when we were all, and some of us still are, very scared about what was happening and seeing the numbers in the jails, and it was devastating. And watching what was not being done to take care of people who were trapped and vulnerable. So we were filing these motions, but using our good lawyering that we do in this district, and had a receptive audience in our judges. So I think that was great. And I also think, you know, I never thought being a criminal defense lawyer meant that I needed to be a statistician. And the old joke of, I'm a lawyer, I don't know math, no longer flies when we're talking about statistics. We're a data-driven society now. And the best way to fight against the guidelines, in my opinion, is to understand them, and to understand where they work, and to understand where they fail, and to figure out what they show and what they don't show. And never did I think that Judge Breyer would be one who could sit here right now and tell you the difference between a mean and a median and the first quartile of this. And he's a statistician, and that was not what we thought we were going to be doing in our jobs. But to throw some statistics out there, when we look at the Sentencing Commission's report on compassionate release, one of the statistics that I find so interesting is that as many individuals, people that were in criminal history category 6 as were in criminal history category 1 were granted compassionate release. And in fact, I mean, it was 29.9% of the compassionate release grants were for people in criminal history category 1. 29.1, the second highest, was criminal history category 6. And that shows a lot of things. But one, they weren't based on what someone's criminal history was. 2, I'd venture to say some of the judges maybe looked at those harsh sentences that they imposed and thought, it's enough time, that times have changed, that we've learned a lot in the last 2 years about what Judge Breyer was alluding to, which is long sentences don't work. They just don't. So here's a way to get around it. And then one other thing that I think is important to recognize that we have all seen from this pandemic is that things change and life is unpredictable, and that having escape hatches, having ways to look at things and look at where people are now versus where they were then is an important tool to have. And that the changes to compassionate release that were brought about because of the pandemic can now be used by people who have long-term illnesses, have brain tumors, have all of those compassionate release motions that those of us that have been doing this for a while have tried and filed again and again and again without getting a receptive audience. Now, I hope we'll have judges, prosecutors, probation officers, people in the system, wardens, that are willing to take a second look and see that there are ways to deal with this outside of the box of just keeping somebody locked up. So I have thoughts on the other stuff, but I was sticking with your first thing of compassionate release.
Yeah, and Judge, you wrote a fairly eloquent order in a case dealing with the fact that people's lives changed and the plea agreement should not preclude changes such as compassionate release, that shouldn't be an avenue that's blocked. Did your colleagues discuss that with you, or was there any feedback that you received from either probation or the prosecutor's office? I think you did from the prosecutor's office.
Well, I do. The prosecutor's office, it's the predecessor. They weren't too happy with it, but waivers are very dangerous things because they lead to unintended consequences, and they are a function, as a general rule, of one side holding essentially a great deal of power in terms of the disposition and requiring something which at the time isn't terribly meaningful to a defendant, a waiver of this, a waiver of that, and they require it. And to some extent, I can certainly understand how the government wants to bring finality to the disposition. And indeed, you can look at the sentencing guidelines and say one of the purposes of the Sentencing Reform Act was what we call truth in sentencing. It was that if a person got X number of months, that person served X minus 15%. Everybody knew about it on the day of sentencing. It wasn't up to a parole commission or circumstances later. However, circumstances changed. We all know that. And when warranted, I think that it should go through. I'm pleased. I want to say two things about the government because it's nice to be able to compliment them when I can. Number one, this Attorney General has now made the waiver of compassionate. It has now made a policy that all United States attorneys must honor, which is not to assert or not to request a waiver of compassionate release in a plea agreement. That's number one. And number two, I have now found, and I think we should have a little bit of discussion on this, that with the present administration, United States attorneys are more forthcoming at sentencing as to what they believe the appropriate sentence should be, and they're less wedded to they're less wedded to the sentencing guidelines. And we can take a look at any number of types of cases and see whether in any given situation a guideline sentence is really going to be given or not. Yeah, especially the lawyers here in the Northern District are pretty sophisticated. They know what judges are going to do. Judges have track records and so forth. And the important thing, in my view, is that for the United States attorney and the defense lawyer to be fully engaged in the sentencing process so that a judge will listen to what is the recommendation of the United States attorney? Why? What is it really based on? Is it based on some rote policy where they're just going to, in every case, they're going to recommend this, or is it really fact-based, or based either on the facts of the offense or the fact or information about the defendant? So they have now become, or increasingly becoming, more of a player in sentencing. And they are to be congratulated on that. That's terrific, because you do want to have a honest exchange on the merits for a judge to be able to render a sentence. I've always said there is no, quote, right sentence. There is no correct sentence. It lies within the discretion of the court. Courts try to get it right. They actually do. And it's very, very hard. So anybody that can help in that regard is very valuable.
That opens up an issue that I wanted to address with Jeff, because I've had some cases where the government approaches we specifically agree on a number, recommended disposition that's under the guidelines. I've had that in several cases, and I still can argue 3553. It's not a binding recommendation. It is for the government, but it's always below the guidelines. Is this a new trend that we can expect from your office?
Well, the flexibility has actually been built into DOJ policy for quite some time. And actually, for years before, say, 2020, the actual DOJ manual actually says verbatim, using the advisory guidelines as a touchstone, the prosecution or the attorney for the government should be seeking sentences that reflect 3553 factors. And it does go on to say that typically, and in most cases, the appropriate sentence is going to be within the guideline range. And so, yes, that's the presumption, if you want to phrase it that way. But we've long had a policy that individual AUSAs could look at the 3553 factors, discuss it with a supervisor, and with that kind of approval, make a recommendation that wasn't necessarily bound by the guidelines. Picking up on something Judge Breyer said, and maybe forgive me for stating the obvious, I suppose one of my tendencies, but the sentencing is very hard. It's very hard, right? Without some kind of starting point. Different people measure everything from economic harm, such as the point made about the fraud guideline, to cyber crimes are notoriously difficult to value, and even drug offenses sometimes can be difficult to value as to the individual involved in it, rather than just measuring the weight. And without the guidelines, you're sort of unmoored and without any touchstone to start with. So our policy has always been for many years has been through DOJ to start with the guidelines, look to it. But if the 3553 factors really dictate that you ought to go out of it, talk to your supervisor about it, and there is the ability to get approval to go outside of it. So I think the sorts of things that Judge Breyer's talked about, DOJ was, I believe, signed off in the First Step Act or joined in recommending the First Step Act. And there are aspects of that reflect this guidance that we're supposed to look at individual factors and cases to determine the appropriate sentence. And I think we're going to keep doing that while using the guidelines as a starting point.
I don't know, in my cases, I don't know if this is true, that I'm getting in prosecutors who are more seasoned, who have been around, who approach me, and we are able to reach a variance, basically a sentence that is a variance, which I'm not necessarily seeing as much with younger prosecutors. So I'm wondering what type of direction there is in your office, or is it all coming from Washington, or is the new direction of the office to approach every assistant and explain to them that they're not stuck with a guideline sentence?
Well, since we are, connected to Washington, we do follow the DOJ policy. And again, forgive me for the repetition, but the policy is to start with the guidelines and then look to your 3553 factors. And again, those factors, as we all know, involve everything from, and they contain concepts that are worth reflecting on for a moment, because they are also subject to interpretation, reflecting the seriousness of the offense, promoting respect for the law, what's a just punishment, will the sentence protect the public, avoid unwarranted sentencing disparities, which of course is, what the guidelines are driving towards. So in interpreting those factors, by definition, right, can have some level, I suppose, of subjectivity when an individual AUSA looks at it and thinks, how am I applying these concepts to concrete facts? And I think what we want the AUSAs to do, we have an incredible group of people. We're so fortunate to have the folks we have joining the office and working for the office, is to bring their experience and their knowledge of the facts, which we hope is deep and thoughtful in every case. And through consultation with their supervisors, who are going to, potentially be a little bit more experienced, start with the guideline and then make a recommendation, and through a reasoned process, decide, what's reasonable. The guidelines are presumptively reasonable. The Supreme Court's found that. But is this a particular case where it's appropriate, potentially, through consultation with their supervisor, to get to a result such as the one you described, Randy Sue? And there's some cases where that will be appropriate. It probably won't be most, and it might even be atypical, but there'll be cases that are going to fall into that category. And I think the thing is to identify them and have a good, thoughtful process, and then be able to support, people when they feel that's the right way to go with it.
Jody, do you have any response to that?
I have a response that we might lose Judge Breyer in a minute, and if we do,
Oh.
we're working on a contingency plan. But in response to the substance, I think that, on some level, I will be totally honest, it's not so bad for the defense that the government just gets sometimes ignored from the conversation, because they're talking about the guidelines, and when there's clearly not a guidelines case, and it's not a guideline case, and then it becomes a conversation between the defense lawyer and the judge. So I do think that we can get at more reasonable negotiations if, in fact, it happens on the ground what Jeff says they're allowed to do, which is have prosecutors use their individual knowledge of the case, knowledge of the facts, in consultation with information that the defense gives them that they may not know about. And that's one of the things that I feel like is sometimes lacking, which is there's a pros memo written based on the facts that the government knows at the time they charge the case. And our job as defense lawyers is not nothing. We learn things that they may not already know. And the hope is that the prosecutor will engage with us in a meaningful way to hear what those additional factors and facts are, such that they can re-look at what the circumstances are. And there may have been something missing. There may be some other way of viewing it that allows a deviation from that. And so the worst thing you hear is, nope, this is all I got approval for this, and this is what I got approval for. And as the defense lawyer, you're saying, well, you got approval for that before you even knew this factor, and this factor. Please go back to your supervisor. We do have wonderful bench. So we often just
yes.
leave open. I thought you weren't listening right then. That was supposed to not be for your ears. But it does give us a backstop, except when there are mandatory minimums. And that's what I'm hoping that this administration gets away from, which is if you have you think there's a value of a case and you think you can make your case for that to the judge, do it. But don't use the mandatory minimum, and particularly don't use that as a threat if somebody goes to trial and give them that as a trial penalty, which is, a separate and related issue to the guidelines. But I think it's helpful if we're all sort of step away from mandatory minimums, advisory, but yet seemingly mandatory guidelines, and look at individuals as individuals. Our case numbers are not so high that we cannot do that for every individual. And every individual that comes through this court deserves that. They deserve for people to look at that human as a human with their pros and cons and all the in between, to figure out what is a reasonable and appropriate sentence.
This week, we heard a lot of discussion with Judge Jackson's confirmation hearing about child porn cases and the guideline sentences. Judge, do you think there's going to be a change in light of all the controversy that the Republicans sort of were trying to stir up? Will the mandatory minimums change in any way?
Well, I think, first of all, that the mandatory minimums are, of course, antithetical to the sentencing guidelines. They focus on one or two particular factors to the exclusion of any number of the other factors that are set out by Congress in 3553A. So I think no commissioner that I've served with thinks that the mandatory minimum is a good idea. And I think a lot of judges don't think it's a very good idea. You're asking how will Congress respond? Yeah, you're asking the wrong person. I don't know. I listened very carefully to what Judge Jackson said, and she accurately portrayed what the commission was looking at in terms of child pornography. And the fact is, the technology, among other things, has appreciably changed. It's no longer the day that somebody's carrying around a few pictures and shows them. And I'm not, by the way, I'm not minimizing the impact that a few pictures or one picture can have. I'm saying it's changed. And now it is thousands of pictures that are downloaded in a second on a computer, because at the time that the sentencing guidelines were enacted with respect to child pornography, a computer was not widely used. And so it turns into an enhancement or a special offense characteristic. So will that change? I don't know. It's a hot political issue. The problem the new commission is going to have is that, assuming they can agree on a whole new set of sentencing guidelines, calculations and so forth, will it get through Congress? And so I've asked the staff, in anticipation of my departure, to give some thought to both what can be done in terms of congressional action. That is to say, what can the Sentencing Commission do which will require congressional action, and what can the Sentencing Commission do without congressional action? And they'll approach it, and of course their decisions will be their own. So that's an issue that that I won't participate in, but a new commission will.
When you were serving with other commissioners, Your Honor, were you able to make more progress than the Senate and Congress seems to make?
Oh, yeah. I mean,
Were you more of a colloquial group like you are here in the Northern District?
absolutely. I mean, there was, even with people who fundamentally you might have had serious agreement as to sentencing policy, we were always able to discuss it, to discuss the ideas, and to see if we could get some common ground. And that is, whether this commission is unusual in that regard or not, I attribute it actually to the leadership of Judge Patty Saris. She was always looking, and she's the chief judge of District of Massachusetts. She was the chair of the commission when Ketanji Brown Jackson was a member. She was also Ketanji had clerked for her in the district court, but she would look for a consensus. And also Bill Pryor, the chief judge of the 11th Circuit, looked for a consensus. So it doesn't make a difference whether you are a Republican or a Democrat or a conservative or a liberal. If you want to try to do something, then you have to be willing to compromise and try to figure out a consensus. And that's the way the commission operated.
Okay. Catherine, I'd like to turn to you and to loop you into the question we were talking about variances, because I've done a lot of cases in Eastern District of California where variance is just not a word they've heard of. And it appears that it is more common here in our district. Was there any policy position that probation took, or did it depend on the individual officer? And you were a supervisor, so.
Right, and I was very fortunate to come from another district, and I think even Ms. Linker has admitted to being a little worried that I would bring some of my practices from the Central District of California and, you know, try to weave them into my work here. I was fortunate enough to be writing pre-Booker, and I came back to the federal system and Booker existed. And I remember asking someone, like, how do you know when to vary? Like, what are those things? And it is helpful, I think, just like when you get a more seasoned prosecutor, if somebody's got, you know, a whole plethora of cases underneath their belt, they kind of know where a case should fall. And I will tell you, I think our district, as the probation office in this district, is very good about recommending variances as well. I think they are very in tune with recognizing that sentencing is individualized and that we should be looking, you know, at the things that address a defendant's individuality. I, as you know, have also, you know, as part of my new career as a mitigation specialist, I have been exposed to some of the things that go on in the Eastern District. And you're right, there is a practice there of almost adding enhancements in many ways. And it's very different for me to come from, you know, I was very lucky to be in the Santa Ana court in the Ronald Reagan courthouse, where I had 3 judges, and we would sit and meet and talk about what outcomes should be. And I feel like that really sort of shaped me early on to recognize that, you know, punishment is part of the equation, but we also want people to return to the community and really be equipped to not come back. And that is something I think when probation officers make recommendations, they definitely try to see a case on its own merits. And I mean, Jody might disagree to some degree that it might not happen enough. And that's fair. That's her, you know, the position. But I definitely think there is a definitely more than my colleagues in other areas of the country. I have colleagues, former colleagues in other districts who have never recommended a variance, and I can't even fathom what that would be like.
Do you think you're spoiled by our district?
I absolutely feel like I was fortunate to be part of this district.
Well, and I might add that, and I've said it in other times, but we're very lucky to have Catherine was an outstanding probation officer, and I'm glad that she's going to continue, even though not with the government, and she'll be welcome in every single court. Every single judge would welcome her because she brings with her an enormous amount of experience. The problem with criminal law is, I mean, there are a lot of problems with criminal law, but one is that it is very experience-based. You know, judges have to make judgments, and they're concerned about any number of things, including recidivism. And those are issues that aren't so easy to understand. And if it's the first time or second time you get a case, you become very reluctant to reach out, to go out of the guidelines, to go into something that's different, to take chances. And so, you know, I think we'll benefit from her service in the future as we have in the past.
Okay. Judge, I'd like to turn to something that I know is important to you, which is the judiciary sentencing information, or what's called JSON, JSIN. Can you explain what it is, how you use it, and what you anticipated that the parties would do with JSON?
Sure. First of all, it has become somewhat of a controversial tool, and I know that that Jody will take it. Will take this opportunity to point out the things that, in her view, are wrong with it. But let me first tell you what the original purpose was, and I think it will serve that. The sentencing guidelines were formulated based upon sentencing practices in the 1980s. That's how that, not for everyone, but that's not for every crime, but for the most part, those ranges were ranges that grew out of the experience of judges sentencing people to jail or probation in the 1980s. And obviously, over 35 years, there have been changes. So JSON was designed to tell judges what the sentencing practice on a nationwide basis for federal judges of the last 5 years. And it is keyed to the particular offense level, the particular guideline, and the particular criminal history. And you go to JSON on the website, and you plug in those three things, and you will find out nationally what the judges, not a particular judge, but what judges have sentenced individuals to over in the last 5 years. It's also broken down to what percentage get probation, what percentage get imprisonment. And the fact is, even if you don't like it, the fact is 90% of federal sentences have one form or another of imprisonment. Probation is 10%, basically 10% for federal offenses nationally, not reflecting whatever the practice of the Northern District is. So this is a tool that judges can go to, and practitioners. It's open to everybody on the website to have that statistic. It may or may not be valuable in any particular case. And a judge can consider it or not consider it, or consider it and discard it if the circumstances of that case seem not to warrant its consideration. So it's a tool. Now, it's a tool in transition. A number of people, especially Defender Services, have made a number of suggestions, most of which we have included in restructuring the tool to take care of particular problems. It's not perfect, and it'll undergo a number of other changes, but it's our intention, when I say our, it's the judiciary's intention to run a pilot project with this information in sentencing reports and pre-sentence reports. And there'll be 10 districts or so that will have it as a matter of the project. Judges will have it in front of them. And then we'll see what happens. But, when I sit down with the judge, I said, would you want to base your opinion on the practice in 1980 or in 2015? I mean, there isn't a judge around who says, oh, they were a lot smarter in 1980 about criminal sentences. So it is to try to accomplish that. One other thing, because the question is, why is it national? And it's national because the statute itself is geared towards developing a national, trying to avoid disparities on a national level. So let's take child pornography, for example. There you see that approximately 29% of the sentences are variances or do not follow the guideline. The reverse. 29% do follow the guidelines, and over 70% do not on a national basis. Let's say you're a judge in Omaha. Let's say it's the first child pornography case that you got. So you can look at the guidelines and the sentences will be very high. You can look at the practices of federal judges across the country and you'll see substantial variances. And it's my view that that judge in Omaha will look at that statistic and think, well, maybe I shouldn't give a guideline sentence. Maybe I should be more in tune with the national average. On the other hand, given the Northern District of California, and Ms. Linker will speak to this, she will say, anticipating it, look, judges now in this district don't really follow all of these guidelines. So maybe they'll give stiffer sentences. Well, maybe I should let Jody speak to this.
Okay, Jody.
Doing such a good job speaking for me. Why would I even chime in? I'm so good at being quiet. So a few things. 10 districts are going to be the pilots. I hope it's not this district. Let's just start with that. And it's exactly for the last reason that Judge Breyer just alluded to, which is our district has, I think, he's going to correct me because he might even have the statistics in front of him, only 30% of sentences are within the guidelines. So no thank you for more guidelines. And I think one of the things to know about Jason is that it is in fact probably going to be good in certain districts or certain offenses. It may actually be good in this district for what Judge Breyer was talking about earlier, 2B1.1, because while the sentences in this district may be lower than the national on gun cases and drug cases, I ran a couple numbers myself, and it's a little different when you look at the 2B1.1. So the one nice thing as defense lawyers, and I'm not giving any little secret to Jeff here or any of the prosecutors on here, we use what's best for us, right? And we argue it and leave it to the other side to argue the other position. It's an adversarial system. And so if Jason and the statistics in Jason work for your client, it's great. When they don't work for your client, they suck and they're horrible and everything is wrong with them. There's so much discussion. We could spend a whole hour talking about the flaws of Jason. I won't go into it, but one of the flaws will maybe be changed, which is only including sentences of imprisonment rather than total length of the sentence, meaning they don't include the probationary sentences in the averages and in the median, so it skews that number. The other is that mandatory minimum sentences are not excluded. So if you look at what the sentences are, the average sentences are, for example, child pornography offenses, you're looking at 2G 2.2, which includes transportation and receipt offenses with a 5-year mandatory minimum and possession offenses without a 5-year minimum. So if you see an average of, say, 52 months, which is exactly what it is, that's not necessarily a reflection of, if you don't have the mandatory minimum, what your sentence would be. And that's just one example of where Jason and I are not BFFs. We're not going to go out on a date. We're not hanging out. Like, it's just not going to work for us. But we can point that out to our judges, and I think we will, and do a good job. It goes back to what I was saying earlier, which is, as defense lawyers in particular, and even for prosecutors, you got to know the tools. You got to know what's out there, and understand what's going into them and what's not going into them and what the flaws are, and relate that to your particular case to know if that's going to be a relevant statistic or a relevant benchmark. My one overall concern about Jason is exactly why Judge Breyer thinks it's good. I'm worried about it, which is the sentencing guidelines were established in the 80s based on historic sentencing factors. And the principle behind it was a good one. Let's avoid unwarranted disparities in sentencing so that someone in Alabama is not getting a different sentence than someone in San Francisco for the same crime, same background, same this. We all know there's not ever an exact same. If you've done this, you just know there's no exact same. But what has happened, even post Booker, as we've heard from Judge Breyer and from Jeff and from Catherine, the guidelines are an anchor and they have to be calculated. So it still affects a great deal of what Jason's statistics are. And so then you're further anchoring into that same number. So it's not like it's gonna liberate people so much, because the numbers are still, and you will see, pretty close to the guidelines, even if they're a little bit below. But because of that anchor of the guidelines, you're still in that same world of where I believe the guidelines are just generally too high and keep us at that high level. And so that's why I'm not in favor of things that further anchor us to high sentences.
Catherine, when you were in probation, did they have a view about Jason, or did you have a specific view about Jason?
You know, Jason came on the scene sort of in, more recently than not. And I will say, and I don't think Judge Breyer minds me saying this, the couple cases I had with him before I left, he would have me run Jason and send it to the parties. And I found it was a helpful place. And maybe this is where I would say it's a good place to start sometimes. When you look at a fraud, I know that the 2B 1.1 has been talked about, but when I looked at that guideline on one of my last cases, what I found was, for example, with the, you have to look at your criminal history and then your offense level. What I found was it was helpful in forming my recommendation, because I recognized in most of those cases that were at that guideline level, like I think it was like 50% were sentenced below guideline, but to custody time. And again, that's sort of the fraud guideline, right? Like it was, I think it was something like 79% of the defendants got custody at that range, but that almost like 50% were below the range they were prescribed. So it told me that I probably wouldn't recommend a guideline sentence. I already kind of knew that, but it was just a good way to sort of look in. And also recall that if you have a defendant who's got some extraordinary issues, you can say this person's really different than maybe the average. And I think it's a starting point, and it's instructive and helpful, but I certainly don't think it's a place to end necessarily. But like I said, I think I became aware of it probably within the last year.
Well, let me tell you, it's in its infancy.
See, there you go.
It has been changed a lot already. It should undergo other changes. I think Jody's criticism of some of it is well taken, especially unless it makes distinction between mandatory minimums and non-mandatory minimums. It could be misleading in that regard. So I think it will undergo a number of changes. But then, I go back to sort of the individual case. And so you have to be careful when you say, what is the percentage adherence to the guidelines? Because in child pornography, it's very low. In illegal entry, it's very high. In gun cases, it's probably higher. In fraud cases, probably lower. So you have to, every class of cases has adherence to the guidelines and adherence to variances. And it's individualized. It's individualized to defendants, individualized to crime. And it's important to look at those individual characteristics in trying to formulate a sentence. And I don't think anybody would actually disagree with that. Or maybe some people would, I don't know.
Okay.
But again, I go back to Jeff and the U.S. attorney, because I think that if the U.S. attorney comes out and he says, in this case, well, Judge, we're recommending the low end of the guideline. And actually across the country, over 5 years, judges aren't giving the low end of the guideline. They're giving something else. And so you just wonder, you wonder where's the U.S. attorney been? They're in every sentencing. They're there for every single sentencing. So are they not noticing that judges aren't on a national basis going and having a particular type of sentence or range of sentences? And that is what I mean by, quote, being a player. If they have that in mind, and then they say what they want to say.
Judge, Jody mentioned this earlier, but you've said in the past that lengthy sentences do not necessarily result in community safety. What offenses are you talking about?
Okay, well, what happened when Drugs Minus 2 was enacted by the Sentencing Commission? The process was that all these sentences would be going back to the individual judge, and a judge could give a lower sentence, or a judge could not give a lower sentence. And two groups were created: those who got the lower sentence and those who didn't. And the Sentencing Commission followed both groups over 5 years after they were released and studied to see what the incidence of recidivism was between these two groups. That is to say, if people had longer sentences, was there a lower incidence of recidivism versus people who had shorter sentences? And the argument would be, if the answer were yes, the answer, then perhaps a longer period of imprisonment is warranted. And of course, the answer was no. There was no statistical evidence that showed the longer sentence resulted in a safer defendant. Now, that's pretty interesting. And by the way, this is something that the Koch brothers, I mean, one of the great conservative think tanks, have championed, that longer sentences do not necessarily promote public safety. Maybe they have different reasons, I don't know, but they come out the same way.
Okay. Judge, our ATIP courts only focus on maybe 20 or 30 people, offenders in our district. They're not equipped to have, we're not equipped to have everyone take advantage of that. But you seem to approach sentencing in a way that you allow an offender to really prove their post-offense rehabilitation, or you give them a chance to deal with their, talking to them, with their addiction. And alcoholism. And I've noticed that myself in Form 12 cases with you, but do you have a specific philosophy about offenders can give it so that not every case necessarily has to be incarceration?
Well, of course, it is it's an individual philosophy. And I don't know that it's, that my colleagues, they're free to accept it and free to reject it. And there are a lot of good reasons to reject it. I look at a defendant frequently from the point of view of what is the likelihood he'll recidivate, and can he turn his life around, and can he address his drug problem, can he address whatever problems he has. So I am very enthusiastic when I see that over time this defendant has turned his life around, has been serious about working, been serious about his drug addiction, which, by the way, isn't easy. I mean, it's very, very hard to deal with. Those are factors that I take into consideration that are important to me, that are really important to me. Now, I also think that that's true with a lot of my colleagues, whether it's stated or not.
The role of victims seems to be increasing in federal cases in our district, not just in child porn cases, but in fraud cases. And I wondered, do you anticipate the commission taking any specific position regarding how much weight should be given to a victim? Or do you do that personally in your sentencing?
Well, I think the guidelines provided, and the statutes generally provide that a victim has the right to address the court. It's a very important thing. It carries more impact than perhaps some of the other factors do. And obviously, it's a factor. It's a factor to consider. It's important that victims be heard. It's important, and they be heard directly. So, the United States Attorney can say A, B, C, and D, but that may or may not bring some type of closure or some type of sense of justice to the victim who has suffered the crime. And I think it's a court's responsibility, and the probation department does it. as well, to listen to what victims say and hear them, and give them a sense that you understand what they're saying. That I think is very, very important. And I try to do it in the cases that are in front of me. Sometimes it's not easy, but it's important. It's important that that people be heard.
Can a victim coming to court and speaking to you change what your thoughts were of what your tentative sentence was going to be?
Yes, certainly can. Certainly can. I mean, it brings it home. Yeah, it brings it home perhaps in ways that a United Assistant U.S. Attorney would find it difficult to exactly make the same point with the same amount of an impact on the judge.
I'd like to open this up to everyone, what you would like to see sentencing reforms in from the commission. What areas? Catherine, first.
I think for me, adding one of the things the First Step Act did was expand the safety valve, and it would be nice to see that provision codified into the guideline manual that we've been operating as a variance at this point.
Okay. And Jody?
One of the important things that the commission could do as a bipartisan body is recognize the benefits of alternatives to incarceration. And the way the zones are, maybe get rid of that or have that be available to everyone instead of just the zone A, B, C, D. And I think through the pandemic, with more people being home, through our CAP program, with which the government now has rejoined and reinvigorated and given so much to, by just being a party to it, they add so much to it, and the government can add even more credibility, I think, in the alternatives to incarceration and telling people, we know you can do this and we're going to give you a chance to do something different. And I think that the commission could go a long way in stating that as a principle that we now recognize through, as Judge Breyer has said repeatedly, statistical, empirical evidence showing us that it works. And so I think they can use that I mean, I'd love to see it just be gone. We could just have a blank last page. We could just erase it, but that's not going to happen. So talking realistically, I do think that is something realistically that they could do that would go a long way.
And Jeff, what are your thoughts about possible reforms?
I hate to go back to the beginning, but get Judge Breyer some help and get the commission going again and able to look at the guidelines. As the judges mentioned several times, they were drafted in the 1980s and of course been ably amended. But when you start with that kind of a premise that it's built on a foundation that even at that time in the 80s, look back at historic data, there's going to be a need, and we all know this periodically, to take a look at aspects of it. Judge Jackson was talking about in the confirmation hearings about the need to, look at the Fourth Amendment in the context of cell phones and things of that sort. And when you have something that's as important as the commission, I am embarrassed to admit my ignorance that I had not been aware it had been so long since there was a quorum on the commission. And it really seems like it's something that needs to be addressed so that you have what was intended, which is a body able to look at the ability to amend it as appropriate as time goes on. And otherwise you risk something that's stuck. And then if you went too long that way, it echoes the comments made by everybody, which is it doesn't have the same resonance that was intended by Congress and the creation of the whole system if it falls out of step too much. But you need a commission to do that.
Judge, are you aware of any names are being proposed?
Yes, I think that they have vetted a number of people, and I believe that at the conclusion of the vote on the Supreme Court nominee, if it's successful, then they will put forward a slate. And it'll be a bipartisan slate. 3 have been suggested by the Senate Majority Leader, and 4 will be suggested by the Democrats, and the president then will submit a slate.
So there's a possibility you'll be able, still be enacting the chair of a commission that sometime this year?
Well, hopefully it'll be sooner rather than later. By statute, I have to leave when Congress adjourns. So I can hold over, and I am holding over for this year, but it's coming to a conclusion, mercifully for everyone involved.
You don't want, would you rather stay on for a third term?
No, I mean, I think I've tried to do what I can do. Jeff is absolutely right. They'll still gather statistical information. They may or may not make any recommendations in terms of analyzing the data. But the real problem isn't that. The problem is, are the guidelines in step, in touch with the reality on the ground? And the further they vary from them, the less credibility the guidelines have. And so, he's absolutely correct. We really do need a commission. And that's why Amy Comey Barrett and Sonia Sotomayor agreed that has to be done. I think that's probably universal on the court.
Mhm. We have 5 minutes left, and there was only one question that was presented dealing with the child porn. Yeah, I believe you can all see that question, or no? Yeah. Are there any, Jeff, that's really a question directed to you, whether the office is going to go, whatever, relax the mandatory minimums in the guideline range.
Well, the question assumes a global approach to those cases regarding guidelines or alleging facts that would support the mandatory minimums. And we take an individualized approach on charging and on the sentencing recommendations. So the assumption is not correct that there's some policy that no matter what, for example, there's always an allegation of the mandatory minimum or a hard and fast rule you would never go below the guidelines. It's not correct. Now,
And we're talking
those
about child porn cases.
I'm sorry, what's that?
I'm just wanting to make it clear we're talking about child porn.
I apologize. Yes, I should be
That
clear
was my
too.
mistake.
I'm specifically referring to child porn cases, though I think my comment would apply to drug cases as well, or other mandatory minimums. But you're right, I'm focusing just on the child porn cases. So first of all, we make the same individualized assessment in terms of the charging, and then we make the same calculation as dictated by DOJ policy on the 3553F factors as to sentencing. Now, harkening back to the point that I thought Judge Breyer made very well a few minutes ago, one aspect of the child pornography cases is they have real victims, and every one of those images in the 1,000 that Judge Breyer mentioned is a person who's been victimized, and it's a person who's a child who's the victim of a violent crime, and a terrible violent crime, and one that ruins his or her life, typically. So yeah, that's a factor we're going to take into account, and that is one we are required to take into account. The victim, by law, has the right to address the court and express her concerns about it, and it should be taken into account, or his concerns about it. So that will be a part of the calculus, and we will factor that in as to everything else. But it's an important consideration, and when there's the comment of are they too high or not, that's of course I suppose going to be something that's in the eye of the beholder. But I think it's important to remember that all of those cases have people who are victims of terrible crimes that have life-altering consequences, and we take that seriously.
Okay. I'd love to continue, and I would like to hear if does anyone on the panel have questions for each other?
Oh yeah, come on into my court, and I'll have a few questions.
Okay. Well,
Thanks.
I'd like to thank you all for joining this. It's very informative for everyone who practices in the Northern District. So thank you for taking your time. And I'd like to encourage everyone who has watched this to please join the Federal Bar Association. And I will be sending out an email to all the people who did sign up for this, that it will be available, this webinar, for people to watch on our website. So thank you, everyone. Thank you, Judge.
Thank you. Thank you.
Thank you, Your Honor. Thanks, Jody. Thanks.
Thank you very much.
Thank you.
Bye-bye.
Thank you.
Bye,
Nice to
take care, everyone.
Bye-bye.